Distinguished guests, ladies and gentlemen, welcome back. I hope you enjoyed your short break. Without further ado, let us begin session 1, titled Developing User-Friendly Asian Model ADR Services. For session 1, the Honorable Professor Seung-Hwa Chang, Chairman of KCAB International, will serve as a moderator, alongside the Honorable Mr. Christopher Lau, SC, Independent Arbitrator of 3VB. We have distinguished speakers as well for session 1, including Mr. Andrew Seok-Kwan Hong, Vice President of Hyundai Heavy Industries, Professor Jun-Gi Kim, Professor of Law at Yonsei University, Madam Joanne Lau, Secretary General of HKIAC, and Mr. Chae Sung Lee, Senior Legal Officer of UNCITRAL, and Madam Gloria Lim, CEO of SIAC, and Madam Helen Shi, Vice President of the ICC Court and partner at Fangda Partners, and Madam Pui Ki Emmanuel Ta, Independent Arbitrator, and last but not least, Mr. Hiroyuki Tetsuka, partner at Nishimura and Asahi. So now it is my great honor and pleasure to introduce the distinguished co-moderators of Session 1, Professor Seung-Hwa Chang and Mr. Christopher Lau, SC. Without further ado, let me hand over the microphone to our co-moderators. Ladies and gentlemen, please welcome them with a big round of applause.
Madam Anna Juben Bray, Secretary of UNCITRAL, distinguished guests and arbitration colleagues, ladies and gentlemen, good morning. It is no exaggeration when I say, as you've heard from the brief account of the CVs of our cast of panelists, that Professor Chang has put together truly a stellar cast, all of whom have extensive experience with alternative dispute resolution, in particular arbitration, both in an Asian context and beyond. This will be a very interactive format. It will take the form of a fireside chat. So you will also have an opportunity to ask questions of the panelists. However, we ask that before you do that you do not do so until the conclusion of the panelists' session. And with that, if I could pass on the baton to Professor Chang.
Thank you very much, Christopher, for your initial remark. Because I'm the initial designer of the whole program of this conference, in particular the session 1, let me try to introduce what are the general themes of this session 1, while introducing some more specific questions we will pose to individual speakers. As the screen shows, it must show up now. The general theme of this session include, I think the screen shows the questions. The general theme of this session include, first of all, let me just put the first question, that is, are there meaningful set of features which distinguish Asian ADR from those in other jurisdictions? And after that, we'll just explore the next general question, which is whether and to what extent the ADR service providers are satisfying the demand of Asian users. If not, how can the gaps be addressed? So these are just encompassing issues throughout our discussion in session 1. And with these general themes in our mind, we will move on to explore some more specific issues and questions. And the first specific question is whether and how non-adversarial dispute settlement method, for example, mediation or a med-arb or arb-med, can it play an important role to entertain the special needs of Asian users? So we just look to this non-adversarial dispute settlement method in a way to find some method or way to entertain special needs of Asian users. And the next specific question is, are there different demands of individual Asian users depending upon their legal tradition or corporate cultures? If yes, are those being addressed sufficiently? As you may know very well, some of the Asian users are based in common law jurisdiction while the others are based in civil law jurisdiction. And although regionally, geographically, we are just in Asia altogether, the people living in Asia are living with a different cultures and corporate structure and corporate cultures or legal cultures. So we will be just attending to any possible different demands of those different individual Asian users. And the next question is, are there current rules revisions by Asian arbitral institution, which is ongoing, and aim at increasing efficiency of arbitral proceedings, properly making a balance with the party autonomy principle? So there seems to be some race for an arbitral institution to expedite the proceeding and speed up the proceedings and making the arbitral proceedings as efficient as possible. But in doing so, has arbitral institution attended to the need or voices of the arbitral service users? So in that regard, is there any concern about some unnecessary or unintended impact on party autonomy principles? So those are the questions we will specifically address. And after addressing all these questions, all the speakers will be invited to express their wish list to narrow down the gap between the Asian users' demand and the currently provided Asian ADR services. I kept mentioning the wording Asian ADR, so before moving on, maybe we need to define the meaning of the Asian ADR. Let us just assume for the remainder of this session that Asian ADR is defined as ADR, surely including arbitration, involving Asian parties, council, or Asian arbitral institution, surely including a global institution like ICC, as well as involving Asian national law as governing law. So if we can find some Asian element, we may just include that arbitration within the category of Asian ADR. So with this, let me just hand this microphone over to Christopher to raise first question.
Thank you. So let us then begin with some general but fundamental questions. And the first of this is, are there any meaningful sets of features which distinguish Asian ADR from those of other jurisdictions? Could I ask you, Gloria?
Good morning, everyone, and a pleasure to be here. I want to thank the organizers for the many thoughtful arrangements, and it's a pleasure to be here with this panel. Well, to address this question, I thought we might need to step back a little and go back to one of the statistics that Gary mentioned in his opening lecture, which is what are the broad trends we are actually seeing in terms of Asian participation in international arbitration. And I had some statistics to share. And just to give the setting, as you know, SIAC, we're headquartered in Singapore, but we have offices here in Korea, we have offices in China, we have offices in India and the US. And in terms of the swathe of cases we have seen happening in our center, we have seen cases from more than 100 jurisdictions over the past 5 years. And we believe that this is actually quite representative of the volume of trade activity that is taking place in this part of the world. And the top users are China, India, US, and also Asian economies, including Korea, Indonesia, Vietnam, Thailand, Philippines. And of course, we also have users, among our top users, users from Europe and the Middle East. So I think as Christopher and Songhwa have been describing, the question is when you talk about Asian ADR and Asian arbitration, what are we saying? I think we are referring to cases where at least one party is from Asia. The proceedings may be conducted somewhere in Asia. An institution situated in Asia is administering or doing the case management work, or a case where there's Asian law, governing law, or as the law of the seat, or there are a combination of all these connecting factors to Asia. Well, looking at the statistics that we have seen so far, I think it is very hard to make broad generalizations, whether there are very specific features to distinguish Asian ADR. But what we know is that, on the one hand, you can argue that, like all parties, Asian parties, the common thread is Asian parties want time and cost efficiency, they want a fair hearing, and they want decision makers that have the relevant expertise and experience to hear their case. And so, like all the other institutions represented here, I think SIAC also seeks to meet these user expectations. On the other hand, I think, which is one of the areas we'll discuss on this panel, is that what we hear from users, Asian users particularly, is that they want greater choice. They want to be able to choose from a wider diversity of arbitrators, particularly arbitrators who understand Asia. And by this, they mean culture, they mean language, they mean laws, and they mean systems. And so, we have seen in our data over the past 5 years, and I will share further on as we progress through the questions, that we have seen Asian users quite actively using some of the arbitral procedures that we have been introducing over the years in our SIAC rules, including the expedited procedure, emergency arbitration, and early dismissal. And these have all been very well received. And we presume that this is because there is demand for time and cost-efficient processes and procedures to support the arbitration proceedings. And likewise, processes like ARB have come to the fore, where they lean in favor of weaving in mediation. So I stop here and hand the time back to the moderators.
Thank you very much, Gloria. Jungi?
Thank you very much. It's a great pleasure to be here. Just to follow up on Gloria's comments, I think, as we know, our system of arbitration is a kind of a private justice. And the key, of course, is not that justice be done, but that appears to be done. And of course, that's important for our Asian users. Asian users have to feel that justice was done. And then, of course, what will it take? Of course, everybody wants efficiency. Everybody wants, a proper, neutral. But they have to have a sense that the institution or the arbitrators that made the decision were those that understand not only the differences between the laws and the regulations, and of course there are many different laws and regulations and differences within Asia, but of course, as Gloria kind of hinted, the practices, the customs, and of course things like culture. Whether you're evaluating a witness or evidence in a particular situation, and one arbitrator from a different location might view that as a very suspicious answer. They won't have the sensitivity as to why the practice of this particular company was this way. And they might think this is a bit odd. They must be hiding something. That's the type of thing that I think the Asian users would want the decision makers to have an understanding and a sensitivity toward. I think one classic example, of course, is mediation. And of course, the ability to get when it's the right situation, to get the parties on board, to recognize that this is the type of situation that other types of solutions, even outside of arbitration, as an alternative to resolve the dispute, to get them on board, to recognize it, to provide the right solution. That's the type of thing I think would be very much valued by many ADR users in Asia.
Thank you, Jungi, which leads us really on mediation, just briefly on mediation. Perhaps for me to ask Hiroyuki, as the chairman of the Japanese Mediation Center, for his comments.
Thank you. I just wanted to briefly point out that Asia is very diverse in terms of cultures as well as the court precedents and court practices in relation to judges' involvement in settlement. And I also want to point out that parties from some jurisdictions are more amenable to amicable solutions like mediation, but still some Japanese companies have more globalized corporate culture and internal governance. So we sometimes see that they behave very aggressive claimants. Thank you. Thank you very much. With these initial questions, we are now turning to the next substantive question. Maybe this might be the highlight of session number 1. The question is whether and to what extent do ADR service providers satisfy the demands of Asian users? Maybe this question must be posed to the users instead of the providers. So let me invite Andrew. As a frequent user, please indicate whether and in what respect you like or dislike the current Asian ADR services. Andrew?
Thank you, Professor Chang. I should say I would dodge that question in a little bit different manner. The reason why I say that is that from a user's perspective, although the general theme of this conference is Asian ADR, we don't make much meaningful distinction between Asian ADR or other jurisdiction ADR. When you buy a phone, whether it's Apple or Samsung, it does not matter to us. As long as it works, we are fine with that. So, having said that, I should add that one more thing, which is that when we, from inside in-house perspective and from a business perspective, when we decide how to handle dispute situation, we make lots of strategy questions, and among the strategy questions, we don't ask ourselves whether is the counterparty Asian or is the governing law Asian, country law, or is there Asian institution involved. So in that sense, I should clarify that, from a business perspective and user perspective, Asianness of the ADR doesn't make much difference. But I should go one further step and want to share my observations over various ADR services here, so that which can be a food for thought for other panelists. At the risk of overgeneralization and oversimplification, I'll go from the arbitration first. For the past 10 to 20 years, clients, especially the Asian companies, have piled up, built up their experience of the, large, small, arbitrations. So now they are getting the, sense of the general cost and the time duration which is associated with the arbitration. And when I talk to my colleagues in other companies and in the business side in other companies, the kind of general sentiment is that they are moving away from arbitration. They thought that would be a perfect alternative to litigation, but they are learning it is so expensive, so slow. So dissatisfaction is growing up, I should say. And when it comes to the mediation, we have another topic coming next. So I'll deal with more detailed way in that question. But generally speaking, mediation is more of the help, for the parties to settle. So as long as the parties are ready and willing to get the help, mediation is helpful. But there are many situations where parties are not willing to get any help from the outside. In that sense, we welcome the help of the mediation, but with reservation. And the last thing that I would like to mention is the dispute resolution board, or sometimes we call expert determination. That's the least, favorite ADR service from our perspective. Expert determination, dispute resolution board is a mini arbitration and a pre-game to arbitration, but the time and cost is not mini compared to arbitration. So when it comes to the efficiency and effectiveness, the determination and dispute resolution board, we don't feel it's efficient or effective at all. So I should stop here and turn it over to Mr. Professor.
Thank you very much, Andrew. Maybe, I don't know whether you have been surprised or it was just surprised or not. He just mentioned that some potential and actual users of arbitration are moving away from arbitration, and maybe some users feel uncomfortable with the current status of the arbitral services being provided. So that's the reason why we just decide on the specific topic of the session 1. So we need to listen more carefully to the voices of the Asian users. So, Pookie, we all know that you have been working for ICC more than 20 years ago, and you also headed a Hong Kong-based electronic arbitration institutions. So, have you noticed any specific gaps between the Asian ADR services for the last a couple of decades on the one hand, and the demand of Asian users? So after answering this question, if you wish, you may briefly address the perspectives of small and medium-sized enterprises and something about ODR in light of your previous job as a head of the EBRA. Thank you.
Thank you, Seung-Hwa. So what I've observed is a lack of appropriate and affordable dispute resolution options for low and mid-value disputes when negotiation and mediation did not work out. And currently, these the claims, mid-value and low-value claims, are either resolved through the traditional arbitration process, but it means that it is very likely that the total cost of the arbitration end up being higher than the amount of the claims. Or these low-value claims are left unresolved because, again, of the high cost of the arbitration involved. Especially when negotiation and mediation did not work out, it is unlikely that parties will commence proceedings. So there is, I believe, an opportunity for ADR institutions to create simplified, cost-effective, and more expedited processes for low-value and mid-value claims. And for instance, I am aware of a procedure that provides for the resolution of the dispute, the rendering of the final award within 30 days from the appointment of the sole arbitrator under the SCCA ODR online dispute resolution rules for claims below $50,000. There is, I think, another underserved market, which is the small, medium-sized enterprises. As you may know, SMEs account for around 96% of the total businesses. So But we also know that it is a market that is underserved when it comes to dispute resolution. And according to a study made by the Asia-Pacific Economic Cooperation, APEC, 97% of APEC businesses are micro, small, medium-sized enterprises, and 94% of them report problems, disputes when they trade cross-border. So in response to this, APEC has established a collaborative framework for online dispute resolution, ODR, to resolve cross-border business-to-business disputes for low-value disputes, and promoting the use of a 3-stage expedited process that includes negotiation first for 10 days, then mediation if negotiation fails for another 10 days, and arbitration if mediation did not work out. The arbitration stage will last for around 20 days, 10 days for the parties to file submissions, and 10 days for the arbitrator to draft the final award. The APEC model procedural rules are based on the UNCITRAL technical notes on online dispute resolution. These rules are flexible and allow the parties to return to mediation or move to the arbitration, which is the final stage at any stage of the proceedings. The rules are also very innovative because it provides for the same neutral to act as the mediator and arbitrator. So I think that the SME market represents another opportunity for ADR institutions to create simplified and more standardized procedures. And I'd like to now comment briefly on the use of MED-ARB and ARB-MED. In my experience serving as counsel of the ICC until 2021, and in the cases that I have supervised, I have not seen any requests from Asian users for the use of MED-ARB, ARB-MED, i.e. requesting the same arbitrators to act as the mediators in their cases. But what I've seen is parties combining mediation and arbitration, or arbitration then mediation. Usually parties will request for the suspension of the arbitration proceedings pending their settlement discussions. And parties will usually keep the negotiation or mediation phase confidential and rarely report to the institutions whether a mediator has been appointed or not.
Thank you very much. We are now turning to invite a totally different perspective. Jason, you have been working as a senior legal officer for UNCITRAL while dealing with or working with the representatives of the government all across the board, all different parts of the world. And I understand that recent UNCITRAL's work sometimes puts some emphasis on giving an aid to the developing countries which try to implement their own ADR frameworks. So from your perspective as UNCITRAL officers, are there any features that are more prevalent or preferred by Asian jurisdictions as compared to others? Maybe it is a question about the attitude or preference shared by the governments, but by contacting the government officials, you may notice some voices from actual users from those countries. Thank you.
Thank you. It's a pleasure to be here. And it's always difficult when your college professor actually asks you questions to answer. And this is a very difficult task for me. So I actually wanted to answer the first questions on whether and to what extent ADR service providers satisfy the demand of ADR users by saying no. Because let me answer by saying that there is first a need to create demand in the Asia-Pacific region. This does not mean that we need to create new disputes or increase the number of cases for institutions. As you heard in the opening remarks, the proportion of Asia's trade volume in the world trade accounts for about 40% of the world trade. And I think Puki also mentioned this. They were estimated to be about 376 million companies worldwide, and about 53% of those companies are in the Asian region. So there is a lot of things going on here in Asia generally. Now, commercial activities lead to rights and obligations of parties, and dispute resolution is only the means to preserve the rights and to ensure the performance of those obligations. Now, as you mentioned, to facilitate the use of ADR,
UNCITRAL provides support to developing countries, not only developing, but also all different types of countries. And we have seen an increasing number of reforms by governments in the Asia-Pacific regions by acceding to the New York Convention, by acceding to the Singapore Convention, adopting the model law on international commercial arbitrations, the international commercial mediations, and also taking UNCITRAL arbitration rules into account. And as Gary Bowen kind of listed, there's an increasing number of cases being developed in the Asia-Pacific region as well. But in order for such reforms, especially in the developing countries, to trickle down to the benefit of the businesses there, and I think Pookie mentioned the small and medium-sized enterprises, and especially for those small and medium-sized enterprises in developing countries, it takes time. You need to build the infrastructure, you need to have the institutions, you need to train the judges, you need to train the arbitrators. My point here is that the businesses, at least the larger ones in Korea, Japan, Singapore, China, Indonesia, and Thailand, maybe have access to ADR services, but this is not necessarily the case for small, medium-sized enterprises in developing countries. I just wanted to mention that we're talking about very established jurisdictions, but 11 of the 45 least developed countries are actually located in the Asia-Pacific region, and I wanted to focus on the Pacific part, because I think we've been talking a little bit too much on the Asian side. A large proportion of the businesses in those in developing countries cannot gain access to justice through the ADR mechanism because there is no limited or limited service, and they don't know about that, the existence of ADR services as a whole. Of course, one may argue that this is the responsibility of each jurisdiction or the states to provide services through their judicial system as a public good. But I would actually question that argument, and I would question whether the ADR service providers in Asia have a role to play in this regard in providing the public goods to these small and medium-sized enterprises. And that is why I want to summarize saying that ADR is underutilized in the region, not because they avoid confrontations, because not all of the users actually do not know that there is an access to such services, and we need to increase those pool. These services, ADR service providers need to provide not only to the known users, but the unknown users, and the users that do not know the existence of such services. And because I wanted to go back to my first point, that there's the large trade volume and the number of businesses, I think Asia could be a sandbox. I think Anna uses this word quite a lot, but a sandbox to try out different innovative features. And I think Pookie mentioned EBRAM as well, and some of the initiatives by APEC to actually use as a sandbox to kind of develop new ways of ADR as a whole. As Gary Bowen mentioned, maybe it may be time to develop apps where users can swipe left or right in accessing some of the services rather than contemplating a very detailed arbitration agreements. Thank you.
Thank you very much, Jason. Now, finally, it's the time for arbitral institutions to respond or make a comments on what we have heard. Because Gloria already mentioned something about SIA, let me just invite two representatives of the two leading arbitral institutions, ICC and Hong Kong International Arbitration Center. Helen and Joanne, have arbitral institutions like your institution made effort to entertain Asian users in particular? Have your institutions experienced any reflections from the Asian users community? Let me invite Helen first.
Thank you, Professor Chang. Good morning, everyone. I was a court member since 2016 of the ICC court, and being the vice president from 2021. And this is my second term of the vice president. I'm also a practicing lawyer in China, so I just speak from my experience in working with ICC as a court member and vice president. But what I say here may not representing what ICC will do in the future. First of all, Professor Chang, as you already introduced that ICC is an international arbitration institution. The users are not only coming from Asia countries. The top users of the ICC are from the United States, Europe, Middle East, South America, and other areas, other countries. With the history of over 100 years, I understand the ICC goal is to promote arbitration globally. So I'm happy to listen to Professor Gary Bowen's keynote speech this morning, saying more and more parties, not only from Asia, have more choices other than ICC. I think this is what we, as arbitration practitioners, this is what we want to say. You know, offering more opportunities, more chances, more options to all the users globally in the world, not only competition between the arbitration institutions. ICC Court, as an international arbitration institution, of course, they understands the importance of cross-cultural understanding. So ICC made efforts trying to accommodate the needs of Asia users. I just highlight some of the efforts that ICC Court had done. First, ICC has set up case management office in Hong Kong, Singapore, and Abu Dhabi with the case management team speaking local languages. ICC also have a rep office in Shanghai. Donna Huang is sitting here today. Second, from the ICC court leadership, ICC has invited top arbitration practitioners as its court members from 119 jurisdictions, including many Asia jurisdictions such as Korea, Japan, China, and Hong Kong, and Taipei. I see some of them are also here today, some of the former ICC court members, vice president, and also the current court members from Seoul, from Korea, Japan. Happy to work with them together. Thirdly, ICC court had also made a decision to create the Belt and the Road Commission back in 2017 to focus on the dispute resolution needs of the full Belt and Road spectrum, particularly in China. As Professor Chang asked the reaction, as to the reaction, what I noticed from being arbitration practitioner and also arbitrator and also the court member, I noticed that more and more Chinese users are now willing to resolve their disputes before ICC court and other international arbitration institutions. They are more open-minded than like 10 or 20 years before. I think there are many leaders from international arbitration institutions. Gloria from ICC also mentioned the top user of ICC is the Chinese companies. So the Chinese companies are now willing to accept international arbitration. However, when the Chinese users actually participate into the international arbitration proceeding, they realize that they're not familiar with the international arbitration rules, and they are surprised to realize an international arbitration proceeding may take more than 2 years to have an end. So this is something they are not very familiar with. I also noticed that it's kind of the frustration for the Chinese users to deal with common law-based practice, such as document disclosure or cross-examination of factual witness in the hearing. They feel huge pressure in handling those proceedings. I understand, as a lawyer, I understand why they feel so frustrated in dealing with those proceedings, because China is a civil law country, and the Chinese court judge and also Chinese arbitrators, when they conduct court hearing or court proceeding or arbitration proceeding, they seldom use document disclosure. They rely on the documents provided by the parties and gave heavy weight on the documentary evidence. So that's why in the Chinese court hearing or arbitration hearing, it may only take 1 or 2 days. Factual witnesses are seldom called being on the stand to give factual evidence. So this is how Chinese users get used to, this is how they understand arbitration proceedings should be conducted in their mind. So in order to attract more Chinese users, as China investing now in almost many countries, I believe that institutions, the international arbitration institutions, can do more to accommodate such needs, at least to give the Asia users or Chinese users option to choose a shorter version of the arbitration proceeding. Professor Chang, thank you.
Thank you so much. So I really appreciate your additional introduction of the Chinese user's perspective, in addition to your introduction of what the ICC has been doing to accommodate in this respect. So let me now invite Joanne to say something about Hong Kong International Arbitration Center's effort to address these issues.
Sure. Thank you, Professor Chang, and hi, everyone. A pleasure to be here. I echo actually a lot of what the other panelists have said. When institutions think about the demands and desires of Asian users, I think in many ways they are not that different from the wishes and demands of users from other jurisdictions. As Gloria mentioned at the start, they all want cost and time efficient arbitrations, fair hearings. So in many ways, the efforts of HKIAC and I'm sure other institutions as well, they are catered to the needs of both Asian users and wider users more generally. But just focusing, I guess, the topic of today, like Asian users, are there any differences that we need to think about? And I think maybe in 2 ways. One, I think the diversity in the pool of arbitrators is a real issue. In many instances, I think not infrequently, we get requests from parties saying, can the institution choose an arbitrator who is familiar with the cultures and business practices in our respective regions, and if they're in Asia, then often they specify the specific jurisdictions. And I think that means that as an institution, you need to have a wide pool, a good know-how of what suitable candidates are available in the region. And I think the second point, and going to what Jason mentioned, in Asia, I think there are still a large group of users who are maybe relatively new to international arbitration. And I think it's particularly important in those regions and for those users that they feel that an arbitral institution is not remote, that in some way the institution and the arbitrator and the process can be familiar to them, that they feel understood and respected, especially when it comes to dispute resolution. It can be such a stressful process. So I think for a lot of them, they want to feel closer to arbitral institutions. So turning to the efforts that, say, HKIAC has done to address those points, there are a few things. One, similar to, say, ICC, we have also set up representative offices. Of course, we are headquartered in Hong Kong, so in a way that gives us a unique Asian perspective. But in addition to that, we also have representative offices in Seoul, Shanghai, and soon in Beijing as well. 2, I think the diversity and representation in both, at the secretariat level for people who manage cases, I think that's important. So say at HKIAC, in our case management team, we have 6 nationalities who can speak 11 languages. And similarly, at the council and committee levels, including, say, appointments committee who handle appointment of arbitrators, it's also important, and HKIC has done that to ensure sufficient diversity and representation. 3, and going to the point about helping users feel, less remote and for them to feel more familiar with institutions, I think it's important, and we've done that, which is to translate our arbitration rules and important documents and FAQs to various languages to cater for different needs of users. And the 4th point is, I think visits, outreach, training programs are essential. Like we've done a tribunal secretary training program or advanced arbitrator training programs. And in a lot of these visits, I think it's also a two-way process. On the one hand, we want users to understand more about, say, international arbitration procedures and practices, but at the same time, it's also for an institution to really hear feedback from a more diverse group of participants. And just to give an example, say, at HKIC, we have an option for parties to choose hourly rate for remunerating tribunal members. And when I go on visits in some places, I hear lots of feedback saying, oh, the cap on hourly rate is too low. But when I visit some other places, I might get a lot of feedback with people saying that the cap is too high. So I think that illustrates the point that there can easily be blind spots for arbitral institutions. That's why it's so important to go out there and really talk to a wide range of people, including Asian users, to get various feedback to avoid these blind spots.
Thank you very much, Joanne. Before turning to the next set of questions, I think it is the right time for us to invite any audience, especially representing the industries or any specific companies getting involved in arbitral institution, to say something about whether and to what extent they like or dislike the current arbitral services being provided for Asian users. Do you have any person from the industry or from the business side to make that comment? I think Andrew mentioned his firm's perspective, but if we can hear the second opinion or that would be great. We don't have any? Yeah, it's very difficult because the light is very strong. You cannot find.
I think the audience is agreeing to my opinion then.
Okay. Yeah. Yes. Great. You are a great lawyer. Thank you. Then why don't you just turn to the next specific questions?
Yes. Could we then turn briefly to mediation? And Hiroyuki, could I ask you this? You are also the chairman of the Japan International Mediation Center. You're also a senior partner in Nishimura and Asahi, one of Asia's leading law firms. And you're also the head of its arbitration group. There's a perception that sometimes Asian parties prefer and they have a greater appetite for non-adversarial dispute resolution. Is this myth or reality? And do you also see the possibility that mediation will rise and will prosper as opposed to arbitration in Asia? And if that were to be the case, do you see any conditions that need to be met for that to be achieved? And it would be helpful also, I think, in your capacity as the chairman of Japan International Mediation Center, if you could throw any insights on whether there are any institutional efforts being made to accommodate the Asian features of the Asian or mediation service market.
Thank you, Christopher. As I said, Asia is so diverse, but many Asian parties often find a value in maintaining the good business relationship and appreciating the usefulness of mediation, through which a win-win solution may be found. And the Asian parties may also want to avoid the so-called worst-case scenario where they lose in arbitration and have to pay the other party's legal fees and costs. That could be very expensive. Having said that, however, some Asian parties consider that mediation may result in just a waste of time and money, as there is no guarantee that it would work well, and there is no established mechanism to prevent the other party's use of mediation just as a derailment or delaying tactics. So I often find that the starting mediation after constitution of the arbitral tribunal may help to reduce such concern, as the parties should know that once the mediation fails, there is a tribunal there, and the arbitration proceeding will restart immediately. And depending upon the timing of the shift mediation, the parties may have better idea of strengths and weakness of their cases. So it may be the case that well after certain arbitral proceedings go on, the parties may want to have some settlement window, which may include the use of mediation. And the reason why a party considers that mediation may not work is very much differentiated. But in some cases, the parties feel that without having some evidence exchanges or fact-finding proceedings, it is very difficult to evaluate the weakness or strengths of the case, and settlement discussion is very difficult. So I have used a so-called mini depositions or mini document production on certain very limited issues, so as to assist the parties as well as the mediators to have the better understanding of certain very important substantive aspect of the case. So my point is that you can be very flexible and creative to make the mediation more likely to succeed. And talking about the JMC Kyoto, which is based in beautiful city of Kyoto, we have successfully worked with SIMC, Singapore International Mediation Center, with which we have joint protocol, and under which each institution select one each mediator. So it's a two mediator panel, and the two arbitrator panel may not work, but the two mediator panel may work. And that was case between arbitration case between Japanese and Indian parties, and we, the Kyoto Center, appointed a Japanese experienced mediator, and the SIC appointed Indian origin Singaporean experienced mediator. So without the fear that the sole mediator may not understand the culture or different mindsets, we have the right persons so that the panel can understand the different cultures and mindset, and the case was settled in a very short period of time. Thank you.
Thank you, Hiroyuki. Helen, also as a senior partner of one of China's largest and leading law firms, and as a vice president of the International Court of Arbitration, ICC, could we have your views as well?
Sure. Thank you, Mr. Law. I share Hiroyuki's view that many Asia parties appreciate mediation or friendly negotiation in resolving disputes. I think such appreciation or preference is not only for Asia users, but also for users or business people from other part of the world. I will mention some statistics of the survey done by the ICC and also Beijing Arbitration Commission later. So for the question on whether there will be a growing preference for mediation, I believe the answer is surely yes. With more countries signing the Singapore Convention on Mediation, mediation is expected to play a more important role in the dispute settlement market in Asia. Viewed from the practice and the statistics of the Chinese courts and arbitration institutions, Chinese parties are have very open attitude towards mediation. According to a recent report published by Beijing Arbitration Commission, which takes more than 12,000 cases in 2023, nearly 70% of the respondents surveyed believe that mediation helps in resolving their disputes, even when the mediation is not fully successful. So meaning the respondent believe the mediation can bring the gap of the differences between the parties into a smaller way. So the ICC survey also reveals generally a common trend across cultures. Around 77% of leaders from business around the world prefer an amicable resolution, such as negotiation or mediation, compared with arbitration and litigation, and arbitration or litigation. So I think this is what business people or the user of the mediation or arbitration service need. And the Singapore Convention on Mediation was just right on time to accommodate such need of business. Thanks to UNCETRAL for the wonderful work they had done. It has marked a new chapter in the development of international commercial ADR. Currently, 57 countries, including China, the US, the UK, have signed the convention, Singapore Convention, but only 14 have ratified it. With more countries to sign this convention, it may have the same or even greater influence, in my view, like New York Convention. In terms of the institutional rules, how the institution to adapt to such change, in recent years, arbitration and mediation institutions are striving to meet demands by providing more efficient and user-friendly services. Many institutions have amended their rules to respond to the need of users for lower cost and higher efficiency. ICC has also made efforts in its rules by publishing the 2 new set of guidelines in relation to mediation and other techniques in managing conflicts. You can go to ICC website and download those 2 guidelines. I think I will share for now, yeah. I think I answered all the questions. And welcome for the questions from the floor.
Thank you very much, Helen. Perhaps then we could turn this opportunity to turn to the business user. Andrew?
Yes, everything has pros and cons. From the business user's perspective, the strengths or advantages of mediation is the time and cost efficiency. It's not, it's short and it's relatively inexpensive compared to arbitration. So there is that attraction to the business user. The issue from the user is the effectiveness. As Hiroyuki mentioned, there is no guarantee of success of the mediation. Actually, we are doubtful as to whether we can reach settlement through mediation. I've been involved in several mediation cases, and unfortunately, I have not had the joy of reaching settlement through mediation yet. So, according to Helen's statistics, 77% of the business people prefer mediation. So I should learn from them. But I think another reason for that is perhaps you asked the question of comparing between mediation and arbitration litigation. If you ask comparison between the mediation and negotiation, I think the result can be different. At the end of the day, I also think about why our mediation failed and what would be the key to success of the mediation. My opinion is that it's very party specific. The party's willingness is very key to the success. There are two groups where the mediation would not work. The first one is a party who does not want to make any decision averse. There are parties like that. They don't want to make any decision or sign off anything. So they want third party to make decision for them. So mediation does not work for those group. And the other group is a party with very strong grip on case. They want to make a whole decision and they don't want to get help from outside. This can be a very much of the overgeneralization, but I feel Asian parties have strong, generally have a strong sense of the ownership and the decision grip on the decision. So when we negotiate in a dispute situation with Asian counterparty, we during the negotiation we sometimes ask, yeah, we have talked a lot. What do you think about we go to the mediation, get some help? Many cases, the answer I get back is, nah, we don't think it will work. We don't need the help. If we have the willingness, we can find a way. Why do we go to the third party? Let's sit down and keep talking until we find the solution. So you see, increasing number of the mediation cases, perhaps, but there are also other side of the world where we just simply say mediation. Well, if we have a willingness to negotiate and settle, we can find the solution. So this is very case by case situation, party by party situation. So this is very much of my personal opinion. So I'm not in favor of mandatory mediation. I want to have the option of mediation available, but I want to assess the situation and the level of willingness of the counterparty to settle, and then make a decision whether to engage the mediation or not. So mandatory mediation, something to think about from user's perspective. Thank you.
Well, Singapore has been quite active in promoting mediation. Gloria, could I perhaps seek your views?
Yes, thanks, Christopher. So, I think what we hear, and based on our experience, that what we hear resonates with what Andrew shares. There's openness to mediation, and there are indications that companies and in-house counsel, depending on the case, are happy to consider use of mediation. But I think it's still early days, and maybe just to share, for example, SIAC has, for many years, we've worked with the Singapore International Mediation Center prior to the Singapore Convention on this process called the ARP process, where mediation is kind of embedded within the arbitration process. And of course, the concept is to convert the settlement agreement into a consent award that is then enforceable under the New York Convention. And so far, formally under this protocol, we have seen more than 40 cases, and of course those cases where the parties were willing, we have found that mediation has been useful. But I would then make this observation that until the Singapore Convention has a significant number of ratifications and countries signing on, the New York Convention using hybrid processes such as ARP is an option that companies can consider. And then maybe just going back to my earlier promise, I will share some statistics also on the more traditional use of arbitration and arbitration processes. And I got my team to dig up some statistics on our use of the expedited procedure, which we introduced in 2010, so more than 10 years of that emergency arbitration 2010, early dismissal 2016, and ARPMET up 2014, which I just shared. And you will see from our statistics that, for example, I'll just give some examples because of time constraints. In the expedited procedure, for example, over the past 5 years, out of a total of more than 400 expedited procedure applications, we saw about 96% of these involved at least one Asian party, and they included users from Singapore, China, India, Malaysia, Thailand, South Korea, Indonesia, Vietnam, Japan, right? And likewise for emergency arbitration, the top users came from, Singapore, India, China, including Hong Kong, SAR, Malaysia, Thailand, South Korea again. So you can see that the Asian users are also tapping on the traditional arbitration process, and in particular looking at the processes that would speed up, would help save them time for the arbitration process and in solutioning their disputes.
Thank you very much, Gloria. Now it's time to move on to the next set of questions. As I initially mentioned, Asia is composed of different legal traditions and corporate cultures. And currently, as the ICC statistics indicated, which was shown by Gary Bourne in his keynote speech, most of the leading Asian arbitral institutions are common law based. And you also know that the absolute majority of Asian arbitration users are based in civil law jurisdictions. And Asian users' legal and corporate cultures relating to dispute resolutions are also very much diverse. And some major countries' users are, for example, under the Confucian influence, whilst others are not. So, my first question goes to Pookie again. As one of the most experienced institutional case managers, have you experienced different approaches and different demands from the users, if any, depending on the legal or cultural background of such users? Do you think that the current Asian arbitral services satisfy special demands, if any, from the users under these two different legal traditions and diverse cultures? Thank you.
Thank you. So the answer to the first question is yes. I have observed diverse approaches, demands, and expectations depending on the legal or cultural backgrounds of the users. But I also think that the users' specific demands can sometimes arise from their unfamiliarity with international arbitration or with the rules and practices of the institution, which in turn may influence how they approach and handle their cases. An example that comes to mind is a case where a party objected to an ICC court decision on the grounds that the decision was not notified, communicated to the parties in the form of a formal court judgment. The party alleged that the ICC court decision was therefore invalid. So this situation demonstrates how counsel expectations may be influenced by their own legal practices and by their misunderstanding of the role of the institution. Another example, Asian users may feel that there is a lack of transparency in how decisions are made by the institutions. So I believe that here a better communication between the secretariat, the institution, and the users is needed throughout the process, clarifying the procedure, the rules and practices of the institution. But I think the key question here that we should ask is how do we address this diversity effectively? We've mentioned, the diverse cultures, languages, legal backgrounds involved in Asia. So I believe arbitral institutions, and as we have heard from my co-panelists, Gloria, Helen, and Joanne, we need institutions with a multicultural case management team able to handle various types of cases involving parties from different countries, fluent in various languages, including Asian languages, and able to assist the parties by addressing their concerns and queries throughout the process. And more importantly, a team that is able to understand, recognize, and respect the various culture and backgrounds involved to ensure a fair and equitable arbitration process. And regarding the question as to whether the current Asian arbitral services satisfy specific demands of the Asian market, I believe they generally do. ADR institutions, as we have just heard, have expanded their presence in Asia and have tailored their services to meet diverse needs of the Asian users.
Thank you very much. Now, why don't you hear from Hiroyuki? Would you like to share with us some comments from the perspective of experienced arbitration counsel as well as experienced arbitrator? Thank you.
Thank you, Professor Chan. I think parties from civil law jurisdictions in Asia and their counsel sometimes find that arbitrators from common law jurisdictions, particularly chair, having no civil law backgrounds, have difficulties in understanding even some very basic civil law concepts, and they may feel that introducing an expert's opinion on such basic issues would make the arbitration more costly and expensive, because such kind of legal experts may not be necessary in national courts. So efforts have been made by many institutions so as to have a nice list of arbitrators who are qualified both in civil law and common law. And also we have some idea as to common law-based arbitrators, but have handled many civil law governed arbitration cases, like Christopher. So I think there have been good developments in that aspect. But sometimes Japanese companies, particularly the small and medium-sized enterprises, are unfamiliar with the common law style proceedings like document production, and they may not have an appropriate document retention policy, and sometimes they face challenges by being ordered to produce some very candid exchanges of risky and misleading conversations on the lines or WhatsApp, because they have no idea that such kind of chat would need to be produced. So I think educating the less experienced users to deal with such common practices is necessary, so as to avoid some prejudicial understanding that arbitration is very dangerous. And but I wanted to say that the larger, more globalized Japanese and Korean and other Asian civil law corporations have been much more familiar with those common law style proceedings, and that they can often act as a very aggressive party, utilizing such common law aspect. Thank you.
Thank you very much, Hiroyuki. Then we would like to invite Andrew to share with us some comment from the perspective of an in-house counsel. I understand you are educated in the United States as well, but now you are working for a company under the civil law tradition and Confucian influence. So what is your perspective?
Let me divide it into two subtopics. One is the common law, civil law approach difference, and the other is the Confucian approach. When it comes to the common law, civil law, again, I need to divide it into two subgroups: management and in-house, legal department. From management perspective, common law, civil law, what are those? Black cat, white cat, we don't care. Just get the job done and bring the result. Yes, sir. That's the kind of the high-level conversation with the management. So there is not much of meaningful influence in how we act, how we deal with the dispute resolution, in light of the common law, civil law. When it comes to in-house counsel, in-house legal department, as the in-house departments build up their experiences, there was a big frustration over particularly the document production in, let's say, 10 years ago. But now we understand how that works. We understand the mechanism, and now we tend to think that that is a good opportunity to gather a lot of information about the other party, and that can be a good timing to try a settlement. So there is more of active engagement of various mechanisms, embedded in the arbitration from the in-house perspective. When it comes to the Confucian cultural impact, I should focus on the negotiation side. One thing that I really, I have served as a member of board of directors for a joint venture with the Western company and Asian company, still serving as a board of director. And there has been cases where we clashed very strongly between the culture. One example is when the negotiation with the owner side or the counterparty is in deadlock. The question is who should make the concession first, and who should, approach to the other party to resolve the dispute. This can be overgeneralization. Every company is different. Every leadership is different. Their philosophy is different. But as far as I experienced, the Asian parties had a tendency of understanding or acting like, we will let you win first, so that you let us win the next time. So everyone says win-win. We want win-win. What's the win-win? The Western, sorry about the Western culture. Sorry. But my experience was that there was a strong sense of entitlement, and a strong sense of we should win first. So it creates another deadlock. You need to move first. I will wait, but we want win-win. That's kind of the mentality. But in the discussion with the Asian, parties, there is a tendency to understand, and they are being receptive to the notion that let them win first, and then they will reward back. Let's wait. And there was a misunderstanding and miscommunication and big disparity in how to understand that kind of approach. But the Western side of understanding was you guys don't know how to negotiate. That's a stupid way of acting in negotiation and things like that. But at the end of the day, I the more I think about the situation, the more I think there is a deeply embedded cultural influence in our psyche that we should consider the others first. And long-term relationship is important. Perhaps we lose right now, but losing is winning in the end in the long-term relationship. So why don't you let them win first? So there is that psyche difference in cultural difference.
Yeah, thank you very much. Very interesting observations. I also sit as an arbitrator frequently, but I started my career as an arbitrator almost 10 years ago. At that time, I share the same view with Andrew that Korean companies actually suffered from the prevailing arbitration practices, including document production, kind of things. But I think they learn by suffering. And nowadays, Korean companies feel very much comfortable with some major phases of arbitration proceedings. But as Andrew mentioned, some Korean companies are considering moving away from arbitration. So that is kind of a trigger for me to design this session in this way. And I think we still need to dig out and explore what are the lingering, remaining residual concerns for the Asian users, which just become hesitant to keep using arbitration. Anyhow, our last speaker on this topic is Jae-sung once again. We also want to have your comments from the UNCITRAL Secretariat's perspective. Has UNCITRAL paid any attention to the different legal culture or different legal tradition in UNCITRAL's work on ADR for the last decades? And have you ever heard from the users or the government in that regard?
Thank you. We're talking about common and civil law distinctions, but there are very many different legal traditions in the world. And as a body established by the General Assembly to harmonize international trade law, we have a mandate to actually come up with international standards that are applicable in all traditions. Now, that actually sometimes leads to the least common denominator, meaning that is not the ideal for everybody. But actually, in doing so, what the UNCITRAL standards actually provide is the flexibility that allows actually states to enact to the needs of their own states. Now, it is also the case that in international arbitrations that you will not have two parties who are from the same tradition, who are with the arbitrator from the same tradition, with the applicable law and the seat of arbitrations all being in the feasible traditions. That would be very rare, I think. So I think for international arbitration in general, we have to take into context all different traditions in context. But however, when you think about a more rare case, I think when you think about domestic arbitrations, whether when you're only talking about domestic users, it may be possible for states to actually enact laws that are in needs to the more to tailor and cater for the civil law traditions that they have. And I think this is what we have seen in some of the enactments. And that is also because the UNCITRAL model law provides those adaptations, that is, allows them to do so, to cater for the needs and to cater for the users. And this may also be the case for the arbitration institutions. They may cater their rules to actually cater for the users who are only from the civil law traditions, who are happy with that kind of an arrangement. And I think this is something for the institutions to develop.
Thank you very much, Jae-sung. I think it's fair to say, and it's an understatement when I say that we do live in an imperfect world, particularly when we've heard what Andrew has had to say and his reservations or growing reservations about arbitration. There's clearly, therefore, room to improve. But the question is, how do you improve it without compromising the cornerstone of arbitration, which is party autonomy? And so the question I have for the institutions here is, how do you improve efficiency in terms of time and costs without compromising autonomy? I know, for instance, with SIC, HKIC, KCAB, and KCB in particular, that you are introducing rules, or soon will be, on improving efficiency in terms of appointment of arbitrators in consolidated arbitrations, summary dismissal, and the implementation of an electronic ODR system for electronic awards. Would this lead to, or would this meet some of the concerns that Andrew have expressed? Or would it compromise party autonomy? So perhaps we could ask, starting with you first, Gloria.
Thank you, Christopher. So I think when we ask about this question about room to improve and what are the considerations that we need to take in designing rules that will support the the needs of users, I think we're balancing that those basket of wish lists that the users have. They want to save time, they want to save costs, but they also want due process. And so the processes have to be designed with a sense of the proportionality and also give users the flexibility. So to your point on party autonomy, it's about getting ensuring that the users maintain some level of choice and will have a clear framework, right, to choose which rules would best serve the dispute at hand. So for SIAC, we are in the midst of doing our revision for our 7th edition of our rules. And those who are familiar with the revisions would know that amongst various things, we are doing some enhancements. For example, our expedited procedure, which completes the case within 6 months. We're looking at increasing the monetary ceiling from Singapore dollars 6 million to 10 million. And I think that kind of speaks a little to what Preeti was saying, that there are smaller value disputes that could benefit from a faster process, that it has more expedience and allows parties to use it. And then I think mirroring some of the work done in arbitral, we are also introducing an even more streamlined procedure, an expedited procedure, that we are trying to have one that's for very lower claims. I wouldn't say very low, but lower, under a threshold of Singapore dollars 1 million. And in that process, we are offering parties, of course, lower fees, lower rates, 50% of their maximum amounts. We propose documents-only basis. The parties can choose that. And also no document production or fact or expertness evidence. And obviously, in designing that process, we are looking at time and cost considerations for the parties. And in some cases, justice delayed is justice denied, and so we cater to that. We are, of course, also looking at other refinements to lend some weight to parties' choice to negotiate or have mediation, and alongside other procedural enhancements. So far, we have received very valuable feedback from Asian users, and there's a lot of support for our streamlined procedure. So we're looking to see how we can develop that.
Thank you, Gloria. Now, I know HKIC is equally innovative. So, Joanne, could you tell us what HKIC is doing?
Sure. So HKIC completed its latest rules revision process earlier this year. So our 2024 administered arbitration rules came into force 1st of June this year. So we've had over 100 cases administered under the 2024 rules, and it's been operating well. But I suppose by way of overview, I should say this is not an overhaul of our previous edition, which is the 2018 rules. The version where we introduced the most major changes was the 2013 rules, where we introduced like complex arbitration mechanisms, etc. So 2024 rules, I would say, is more a refinement of the previous edition. But turning to your question, Christopher, for HKIC, our ethos has always been to adopt a light touch case administration approach. So to the largest extent possible, the institution would give deference to party autonomy and will try not to interfere as much as possible, even though in this latest version we did provide for some powers for the institution to step in, say if it's something to do with integrity of proceedings, but those would only apply in really exceptional circumstances. But just to give a summary of the main changes introduced in the 2024 rules, I would say 3 broad categories. The first one is time and cost saving measures. on that, some of the changes we introduced include, for example, introducing a time limit for closure of proceedings, because we always had a time limit for when a tribunal should issue an award, and that runs from when proceedings are closed. So we have to fill the gap to also introduce a time limit for closure of proceedings as well. The other one is to add a provision to clarify that tribunals have a range of case management powers. That is not new in the sense that you might say tribunals always had that inherent case management powers, but we wanted to encourage tribunals, like not just institution, to also be a bit braver in adopting assertive case management powers. The second category of changes, as I alluded to just now, is in relation to efficiency and integrity of arbitration. So say, just to give an example, in the latest version of rules, when parties want to propose a change of counsel, they need to inform the tribunal in advance. And on confirmation of designated arbitrators, the institution HKIAC can now also take into account efficiency or integrity of the arbitration, although in most cases, as I said at the start, we would give deference to party autonomy. And the final broad category of changes is just to respond to developments in the world, in international arbitration. I think one of the more exciting ones, and tying back to the first point, the first section on diversity. So we added a new diversity provision, which says that co-arbitrators and parties are encouraged to take into account considerations of diversity when designating arbitrators. And for an institution, we also put it in our rules, even though it was always our established practice, that institution must take into account diversity when appointing arbitrators. And this one has had a lot of feedback both during the consultation process and after its introduction, but I'm pleased to say that it's been received very well, and we already have cases where someone is commenting on how that provision has changed their approach when coming up with names for designating a presiding arbitrator.
Thank you very much, Joanne. Now, KCAB International. We do know you've got some very surprising news on your rules that are going to be introduced shortly. Jungi, could you, as the chairman of KCB International Arbitration's Rules Revision Committee, tell us what they are?
Great pleasure, Christopher. As you, for those of you that have been in Korea or recently arrived, Koreans, I guess other Asians as well, but we have a real strong obsession with speed. So in Korea we call it 빨리 빨리. Everything has to be 빨리 빨리. So we're very impatient. Things have to happen quickly. Korean's version of Amazon, I've done this before, but the night before you can order something, you'll get it in the morning. That's how fast things move. So we've, excuse me, we've looked at the rules for my colleagues and we've endeavored to really, I mean, the rules actually are quite efficient, and we think that even in practice, KCB rules are designed to move very quickly, and in practice, you'll get awards, we think, and we're quite proud of this, quite quickly, without sacrificing quality. So it was quite a challenge to try to find places where we could further expedite things, and we think we really try to find and squeeze whatever we could find. And some things we think that will help. One thing that we found was in the process, particularly for instance for the sole arbitrator, usually of course we gave the parties 30 days. But we found, this is of course in terms of in compliance with party autonomy though, but if one party says, we're never going to agree, from maybe even from day one, and it's not KCAB to appoint the chair. So we think we found a couple of weeks there, and we're kind of hopefully that's one thing where that will expedite things even further. Another thing that we're toying with, and we're still toying with this, is to have a super expedited procedure. And it would be so fast, and of course this is with party agreement, from constitution to award would be 100 days. So that's what it's not finalized yet, but we're contemplating this. One other thing that I'd like to mention is, of course, with the new rules we're going to adopt an early determination procedure. And of course, other places have this, where you can seek an early determination on certain defenses or claims. And we also think this would be in the tradition of Bali.
Thank you very much. We are now reaching almost the final stage of this session. The duration is a full 2 hours, so thank you for your patience. But I don't think you feel bored, because we have tried very hard to proceed this session in an interactive manner. And the final set of questions is, so given all the different views or concerns already having been expressed, we need to think about what is the solution, or what is the right direction to pursue. So are there ways to improve ADR services so as to better accommodate the needs of users from Asia and beyond? And so I'm going to just invite each speaker to just express their wish list for the purpose of accommodating those concerns. And you may not wish to just reiterate the importance of efficiency or any kind of abstract destination. Rather, you may just mention any specific or more realistic way to address these concerns. Let me first invite Jae-sung, Pookie, and Andrew and Hiroyuki first. So, Jae-sung?
Thank you. I think in order to address the needs of the users, I think there has to be 3 things done. One, we have to address the concerns of the users. And second, we have to provide options to the users. And finally, we have to remove some of the uncertainties. And I just wanted to kind of go back of where UNCITRAL is in this process. We're addressing a specific set of users in the sense that we are embarking on ISDS reform, which is states as users of the ADR services. You will have a full-fledged panel in panel 4 on ISDS reform, so I'll not go into that. But there is this need to address not only the efficiency, but other concerns of the users themselves. Second is to provide options. I think Gloria mentioned it, Anna mentioned it. UNCITRAL's Working Group 2 has also developed Speeder, which is a very expedited arbitration. I'm a little bit getting worried that normal arbitration is super slow, that everybody is developing something super fast, but this is something. But Working Group 2 is also developing model clauses to allow for adjudications, to allow for confidentiality, and to use of technology experts or expert determinations as well. So I think the broadening of the options is one thing to do. And last, I think, is to remove uncertainties, which leads to the current work of UNCITRAL's Working Group 2, because there were some uncertainties about whether it is going to be whether e-awards, electronic awards, are going to be enforceable under different jurisdictions, going to the questions of what is an electronic award as well. Is it only an award that is signed by the arbitrator electronically, or is it that the original awards are in electronic format, in PDF format? So, and the use of different technological means in ADR is, there are a number of questions being posed, whether that is going to be an obstacle on the use of ADR. And I think UNCITRAL has a role to play in clarifying those questions and removing any uncertainties that may arise in these legal standards. And that's where probably UNCITRAL will try to respond to the needs of those users. Thank you.
Thank you very much. Preeti?
Yeah, I'd like to propose 2 ways to improve ADR services. First, by adopting new technologies, and second, by enhancing the quality of institutional services, particularly in case administration. On the first improvement suggestion, even though some ADR services have now embraced technology and we are seeing more arbitral institutions offering an online case management system to users, I think there's still a significant gap in fully using digital tools that are currently available to make the process more efficient and more user-friendly. For instance, technology can be used to break language barriers and also reduce the cost of transcription and interpretation or translation of the transcription as well. ADR institutions could consider offering an online case management platform that not only integrates a case document management system, but also integrates AI technology featuring machine translation for documents, real-time transcription for hearings or procedural conferences, which can be accessed by parties and arbitrators 24/7 without needing human involvement or assistance, with transcript available immediately. Generative AI can also be adopted to serve as an AI assistant tool for arbitrators and parties. For instance, AI can provide support for document summarization, generating summaries of the procedural background of the parties' respective positions, and extracting relevant data to assist the parties or the arbitrators in the relevant case. So what arbitrators or parties need to do is simply upload the party submissions onto the system and give prompts to the AI, and the AI will quickly process the data and extract the essential data. And as we are seeing institutions moving towards using more technology tools, I believe new questions and concerns will need to be addressed, particularly as to data security, data protection, and cybersecurity requirements. And I'm not going to expand on this right now, but simply refer to two reports that are addressing these data protection issues and providing practical guidance to arbitral institutions and platform provider. The first report is the Protocol on Online Case Management in International Arbitration, and the second one is the IBA Roadmap to Data Protection, which offers guidance as to the type of safeguards or policies that could be put in place in terms of data protection. Now, turning to my second proposal for improvement in relation to the improvement of quality of the institutional services, particularly for case management. I believe that ADR institutions have done a great job in improving their offerings, updating their rules, and introducing new procedures. And we have heard today expedited procedure as well, or more expedited processes. But based on my past institutional experience, I believe that more can be done, and ADR institutions could consider looking into how they could first maintain the quality of their services in light of their growing caseload. Second, reduce delays in the appointment process, in the scrutiny of awards, if any. Third, establish more efficient and effective internal practices and processes. Just as arbitral institutions strive to meet the user's expectations with expedited, faster processes, it is equally important for arbitral institutions to maintain the quality of their services to users. And I think that, and I would encourage ADR institutions to continue improving their internal processes and ensure better coordination to avoid unnecessary delays. Let me give you a straightforward example. If the expedited rules apply to a case and the award is expected to be rendered within 6 months, it would not make sense for the institution to take more than 4 months from the request for from the receipt of the request for arbitration to appoint a sole arbitrator. So I believe that there should also be strict timelines for institutions when appointing arbitrators, scrutinizing awards, and also rendering decisions as to challenges and consolidation issues. And I also believe final comment that it is not only the duty of arbitral institutions to improve arbitration, but all players in international arbitration, including counsel and arbitrators, have a role to play to make arbitration better by preserving its integrity so that arbitration can remain an attractive option for large corporations, including for Andrew's company. Thank you.
Thank you very much. You must have been pondering upon these questions for a long while, and thank you for your thoughtful suggestions. And Andrew?
Yes, among many other things. Let me emphasize on two things. First, fees. Let me get the beast out of the box. Nowadays, the international law firm, major law firms, and Korean law firms as well, easily go above $1,000 per hour. I'm not talking about the value of the service that we get. We are talking about the hard money that we spend. If you think from our business side perspective, in order for us to make 1 million profit, if we think about 10% margin, which is quite high, you have to sell $10 million product to earn $1 million profit. My rule of thumb is that unless a case goes above 2 million in minimum, don't think about arbitration. The legal fee would exceed the total amount of the dispute. So when I talk to other counterparties, big international oil and gas companies, general counsels, we talk about arbitration, we just shake our heads. This is not sustainable. Again, I'm not talking about the value, but at the end of the day, it's the money spent by the money that we earn from other customers. So we need to think about the sustainability of this community. That's the first thing. And the second thing is the case management. I certainly appreciate all the efforts, systematic and individual efforts to have a very efficient, effective case management of institutions and tribunals. But as a user, we see very often due process paranoia and obvious delay tactics, conflict issues and confidentiality issues, whatever they name, just bring the issue, delay the process, and there is no penalty or no consequence to the other party. So I appreciate all the timeline, suggestions, but unless there is some kind of consequence, breaching that timeline, I don't think the slowness of the arbitration would stay, for the time being. So from the user perspective, the fee and the case management, please. Yeah.
Thank you so much. As an arbitrator and at the same time the representative of arbitral institution, I feel like I have to define the meaning of fees, which was used by yourself. At one time, I took a look at the size of the fee which goes to arbitrators and goes to the arbitral institution in comparison with the fees going to the law firms. And I just found that the portion of the legal fees in the first category is about just 5% of the whole fees. So I think we should keep that in mind. Thank you. And Hiroyuki?
Okay, I just wanted to be brief by just focus on one wish list, that is promotional mediation, including, in particular, a hybrid type of mediation, like ARB-MED or ARB-MED-ARB. And I heard about Korea's efforts towards ratification of Singapore Mediation Convention, and Japan has become the 14th signatory who ratifies access the convention. And during the legislative process, in which I was deeply involved as a member of the subcommittee of the Judiciary Council to the Minister, I heard some voices from the businesses that if the Singapore Mediation Convention doesn't allow the reciprocal reservation like a New York Convention on arbitration, why we should participate? Because if it is a dispute between Japanese and signatory states parties, if we are to pay, the obligation of our side will not be enforceable, but we can enforce our rights in the other party's jurisdiction. But my answer to that question has always been that if that is the case and there's no level ground, why the other party will agree to mediate? Right? So I think having the level ground is the biggest incentive for agreeing to mediation. And because the states that have already ratified is quite limited as compared with the number of the states that have signed the mediation convention, it is sometimes the case that the conclusion of the ARB-MET through the mediation may not be enforceable. But I understand that SIC has been working hard on the ARB-MET protocol with the SIMC. And depending upon the situation, particularly where the party is not from the signatory country, you can then move to arbitration again so as to make the agreed settlement into the consent award that will be enforceable. So I think ARB has a big potential, but the biggest problem is that there are quite a few, quite a limited number of people who have ever experienced that. So what we intend to do is that during the week of 18th of November, there will be the inaugural Japan International Arbitration Week. You are celebrating the 13th, and we are doing the first one now. But on the day 2, 19th of November in the afternoon, we'll have a joint session with SIAC, SIMC, and JIMC on the mock ARB-MET ARB, which is quite exciting, I hope. And I encourage the in-person attendance because it's a very good season to visit Japan. But if you cannot come, we will likely do the online arrangement so that you can see how it works, right? So that is a starting point. And I want to conclude my remark by saying that JIMC provides the very inexpensive but beautiful, quiet venue for the mediation and any mediation rules. So if it is SIC rules, ICC rules, or HKIC rules, or KCAB rules, we accept that mediation as a venue provider. And depending upon subject to the availability, we have some special arrangement with one of the most popular temples in Kyoto, Kodaiji, where you can use the best scenery room, the VIP room for mediation discussion. And they will provide a nice deep green tea at the beginning of the mediation. So it's a meditation before mediation. Thank you.
Thank you very much.
Thank you very much, Hiroyuki. I can tell you, although I didn't say to you earlier, that I'm in an arbitration now. We are seriously considering asking you to let us use your center for us to have our deliberations meeting. Now that brings us very nicely to the last topic in this session, which is a speed round for the institutions. So to the extent that you have not already told us what these are or what this might be, could we ask the institutions to tell us what's cooking, what's in the works with ADR continuously evolving, and will there be any Asian-specific features in what you are going to address? So could I ask you first, Gloria?
Sure. I think what we are cooking will appeal not just to Asians, but to I think all the international users. I think we're looking at designing processes, ensuring that we have an arbitration panel that gives users diversity of choice, choice of procedural tools, choice of decision maker, and higher accessibility to our services. Our career office is here. My colleagues Michelle and Jay are here. And I think last but not least, as Peggy mentioned, the importance of technology. We are indeed looking at technology and increased use of technology solutions to increase cost and efficiency in arbitration. So for lack of time,
thank you very much, Gloria. Joanne?
Sure. I'll be brief and quick, consistent with our theme. I think one of the focus areas, and we hosted an event yesterday on this, I think users are expecting tribunals to be a lot more flexible and assertive in managing proceedings. So yesterday we heard about the potential and positive experiences of using midstream conference. So I hope to see more flexible, carefully designed procedures tailored for each case in the future. The second point, and going to Andrew's point on fees as well, I think other than trying to reduce time and costs of proceedings, the other thing that we've been seeing in Asia is the increase in options on financing proceedings. So I think there's still a lot of potential in using third-party funding and like conditional contingency fee arrangements with lawyers. So something to be considered. On the more practical side, in this region, including in Hong Kong, I think there's a lot of interest right now on refining like complex arbitrations, like how to conduct arbitrations involving multiple parties, multiple contracts. So HKIC is looking closely at that and hoping to issue some practice notes. And finally, to Pui Ki's point, the use of technology. I think generative AI is really a hot topic now. Everyone is talking about it. But in terms of actual use cases, I think a lot of people are still hoping to see more. So I think it's a space to watch.
Thank you. Helen?
What is cooking? ICC is also considering revising the rules, and it's expected to be published at the late 2025. I got approval from Claudia Solomon to announce this. So this is surely what ICC will do. Wish list. I think many speakers already covered EPP, mediation, new technology. I think it deserves ADR community, including the arbitration institutions, to do more on mediation, because we already have Singapore Convention in place. And previously, the community, ADR community, spent a lot of efforts, time for doing arbitration. And we heard what our users said today. Arbitration may, in my view, mediation may play more greater role in future dispute resolution. Thank you.
Thank you, Helen. And finally, Jungi?
What is cooking? I think all that's in my mind is what the cook has cooked for us for lunch. But what's cooking in Korea, just a couple of things to touch upon, is we've decided to include some clear provisions on diversity. Of course, as was mentioned, we live in a very diverse world. So in terms of appointments of arbitrators, that the institution will aspire to consider diversity in their appointments. Second thing that was mentioned is a governance-related issue, and we want to reform the governance of KCAB, and either in the form, we haven't decided the exact form, but probably in the form of like a council or a court, kind of formalizing the existing advisory board that exists, and their function, of course, would be to focus on things like appointments and challenges and review of awards. Another thing that we're thinking that that I would like to consider that is, of course, kind of a negative incentive, positive incentive, carrot and stick. What I'm talking about, of course, is reduction of fees for dilatory arbitrators when rendering their awards. And the flip side is actually to improve the fee structure of the KCAB for arbitrators to make it more closer, to make it much more competitive. That's another thing that where I'm hopeful will occur in the new revisions. And hopefully lunch is waiting.
Thank you very much. As you see, we are now approaching the end of this session. But before completing this session, I just want to have any comments or observation from the floor, if any. Yes, please identify yourself and please make it quick. Thank you.
Anton Maurer from Germany. It was a very interesting panel. However, isn't it true that whatever the institutions do, as long as the parties or their counsel request months for their next round of briefs, we can do many things, but the arbitration procedures will be very lengthy?
If I could just, I was just kind of this. I think I want to relate this to what Andrew was suggesting. I'm curious, actually, from the user's perspective, how often, when the users are looking at who's being appointed as an arbitrator in the tribunal, where they think, "Wow, that person was really efficient." And we want that type of person, as opposed to whoever's being recommended, you probably just accept that person. I mean, from what you're telling us, the users want efficiency and they appreciate that expediency. But actually, when it comes to the appointment stage, how much are they really pushing for that and adding a premium to that? I mean, if you think about it, that's what they should be pushing for. And I think that's what Anton's getting to. But I don't know if you want to.
A very important and very complex topic. Yes, I was thinking about lunch. Two things are most important in arbitration in the cases that we've been involved. One, the tribunal, constitutional arbitration, the arbitral tribunal. Two is the experts. It has become the game of expert. When it comes to the constitutional arbitration, the process is that we get recommendations from the law firm, various names, and we try to have a thorough vetting of the potential candidates. There are a lot of limitations in information. That's what we are suffering. That's one of the things that I wanted to talk, but just let it slip. Hard question to answer. I mean, we certainly want fair results. We want the arbitrator with relevant expertise and experience. At the same time, it's a balancing thing. It's equally important value. Just to have that.
Thank you very much. And as you see from the program, the general theme we have been dealing with and discussing in this session may also apply to the afternoon sessions when they deal with a specific areas or specific industries. So having said that, first, I have to express my special gratitude to all my colleagues, speakers, and my co-moderator, Christopher, for having been very much they have been working very hard to just make this session as efficient as interactive as possible. And our discussion have been very tightly but very well organized from our perspective. And as a teacher, as a law professor, teaching for the last 30 years, I have a basic instinct about how the audience, the student, in my case, perceive or evaluate my teaching or my lecturing. And although you have not been very much active in participating in this discussion due to the lack of time, I could get a sense of feeling that all of you have been following our discussion very closely with very high level of interest. So with that, thank you again. And why don't you just express your thanks to all these speakers with big applause. Thank you very much.
That brings us to the end of session 1 of the 13th Asia-Pacific ADR Conference, titled Developing User-Friendly Asian Model ADR Services. We would like to sincerely thank our distinguished co-moderators, the Honorable Professor Seung-Hwa Chang and Mr. Christopher Lau once again. Thank you very much for sharing your expertise with us today.